Good morning, students. In last class, we have discussed what we understand by consumer, what is the meaning of goods and services. Now, in this class, we'll be talking about other concepts which are important to understand as to when a consumer can bring an action under Consumer Protection Act, for which we need to understand as to what is meant by the term defects, deficiencies, who is a complainant, when can one file a complaint. So it is important to understand that what does the term goods and defects means under Consumer Protection Act, because we are saying that a consumer can make a complaint only when he come across any defective goods. So when we talk about the act, we are saying that as per the old act, it is section 21F that talks about the definition of defects, and 210 is what of the new act talks about defect. So defect means any fault, imperfection, or shortcoming in the quality, quantity, potency, purity, or standard which is required to be maintained by or under any law for the time being enforced under any contract, express or implied, or as is claimed by the trader in any manner whatsoever in relation to any goods or product, and the expression defective is also included within the definition. So what is this definition talking about? It is talking about any fault, imperfection, or shortcoming with respect to the quality or quantity which a consumer is purchasing, and there are certain standards that manufacturer is required to perform, but these standards are not performed under the law which is regulating the quality and quantity of these goods. Okay, so when we are talking about defects, we say that the act recognizes only those defects which are covered by these definitions, that talks about its purity, standard, quality, quantity, potency, right? Any of the defects not mentioned will not be the one that will be entertained by a consumer forum. So we have to interpret these terms very widely in order to understand whether a consumer has is facing any defect of the goods or not. So, like for example, if we talk about a pressure cooker burst and causes injury, right? If you are talking about a pressure cooker bursting and causing injury to the users, it was held to be a manufacturing defect. Another example, like where laboratory test reports showed that soft drinks was not fit for human consumptions, it was also led to be defective. For example, like electric household appliances which are not in accordance with the standard prescribed by ISI, a gas cylinder with excessive gas is defective goods. Like this development of cracks of half inch to 3 inch and a half inch in wall are certain aspects which are considered within the aspect of deficiency. So as a consumer, we have got all the rights to bring an action against the manufacturer in order to sustain our cases where there are defects being suffered by the consumer, by a potential consumer, after once the product is purchased by a good is purchased by the consumer. So this is one of the right which is available to the consumer and which is essential in order to protect their rights. Now the another question comes is as to what do we understand by deficiency. So when a service is found deficient by a consumer, again under these circumstances a consumer can make a complaint under the act. Okay, so thus the prime requirement is that the matter must fall within the definition of services and must entail a deficiency as per the norms which are given under the Act. Now, the Act talks about definition of deficiency under Section 211 of the new Act and 21G of the old Act. Now, if you read the definition, it means any fault, imperfection, shortcoming, or inadequacy in the quality, nature, and manner of performance which is required to be maintained under the law for the time being in force, or has been undertaken to be performed by a person in pursuance of a contract or otherwise in relation to any services includes any act of negligence or omission or commission by such person which causes loss or injury to the consumer, and deliberate withholding of relevant information by such person to the consumer. Now, when we are talking about services under the Act, it considered only a regular commercial transactions. The services rendered under the contract of personal services are specifically excluded from the definition. So, when we talk about the expression of personal services, it is something which is not defined under the Act, but in common parlance, it means a contract to render service in a private capacity to an individual. Like, for example, where a servant enters into a contract with a master for employment, or where a landlord agrees to supply water to his tenant. These are the contract of personal services. The idea is that under a personal service relationship, a person can discontinue the services at any time according to his will. He need not approach consumer forums to complain about deficiency in services. And it does not make a difference whether a service provider is a government body or a private body. But yes, if there is any deficiency in service as provided under the Act, then an action can be taken up under the Consumer Protection Act, and it should be the contract for service and not contract of service, which the concepts which have been already explained in the previous class. Thus, even if a statutory corporation provide a deficient services, in that case also such statutory corporations can be held liable under the Act. Like for example, X applied for electricity connection for his flour mill, which is Rajasthan State Electricity Board, and the board delayed in releasing the connection. So it was held that it is a deficiency in performing the services. Some other sectors, professional services, which are not specifically mentioned in the definition services, but which has been considered by Consumer Forum time and again as services sector, like for example, advocates, airlines, chartered accountants, courier, chit funds, education, gas line pipe, LPG, medical services, postal services. All these have been held to be under the Consumer Protection Act, but there are certain conditions, requirements that have been laid down by the Consumer Forum before putting them under the contract under the Consumer Protection Act for the deficiency of services. So when we talk about this from the definition of deficiency, we can say that deficiency, there are certain essential elements of deficiency. First is where deficiency means any fault, imperfection, shortcoming, or inadequacy in the quality. So within this ambit, a particular person will be booked for deficiency under Consumer Protection Act. Like for example, Dr. A treated P under a particular medical system, though he himself was a homeopathic practitioner, but later on P alleged A for any kind of wrongful treatment. So it can be held that there is deficiency of services. Another example we can take is A booked a car for B and promised to deliver it within a month. The car was not delivered even after 4 months. So here A can be held liable for deficiency. Another important aspect for deficiency is that such quality and manner of performance of service should have been required to be maintained by or under the law for timing in force or undertaken to be performed by a person in pursuance of a contract. Like for example, a builder A, who is a builder, promised under a written agreement to provide flat to B. Subsequently, he expressed his inability to give any possession of the flat and entered into a fresh agreement that to pay some amount to B in place of the flat. So he A didn't even pay this money. B sued A. So the commission can held in this case that since A had not even paid the money as per subsequent contract, the right of earlier contract can be involved by B, and that there was a deficiency of services on the part of the builder. Right. Another third essential is that the deficiency must be in relation to a service. Like for example, here we can take up like A deposit rupees 100 with B as application fees and executed a bond for purpose of drilling a tube well. So B did not drill the tube well because it was not feasible. So A alleged deficiency in services. It was held that depositing 100 rupees as application fees and executing a bond does not amount to hiring of services. Thus, deficiency of services cannot be complaint of the matter. So it must relate to in matter of services that are taken up by a person. Now the next question comes that who can apply, who can file a complaint. So we say that only a person who is termed as consumer under the Act can file a complaint. Hence, these are the following person who can file a complaint, and as per the new Act, it is Section 25 that includes a consumer, any voluntary consumer association registered under Companies Act or any other law for the time being in force, the central government or state government, one or more consumers, where there are numerous consumers having the same interest. In case of death of a consumer, its legal heirs or representatives can file a complaint. So apart from these above mentioned people who are given in the act, the following person can are also considered to be consumer, and this can include beneficiary of goods and services, here a legal heirs of a deceased person, husband of the consumer, relatives of consumers, right? Insurance company can also be taken up as a consumer. So where they can make a file a complaint. So when we talk about complaint, we say that we need to take into consideration that as to what is a complaint or when a complaint can be filed. So an aggrieved consumer can seek redressal under the act by filing a complaint, and according to Consumer Protection Act, complainant means any allegation in writing made by the complainant, and it is given under section 26 of new act and 21C of the old act. So the complaint can be made with respect to an unfair trade practice or restrictive trade practice has been adopted by the trader or any service provided. The goods bought by him or agreed to be bought by him suffered from more than one defects. The services hired or availed of, agreed to be hired or availed of by him, suffered from deficiencies. A trader or the service provided had charged for the goods for services that are mentioned in the complaint in excess of the price as what is required, or which is fixed or by or under the law for the timing for in force, or displayed on the goods or any package containing such goods, or displayed on the price list exhibited by him or under any law for the time being in force, or which has been agreed. So there is excessive price that has been charged by the person. Next is where goods which will be hazardous to life and safety when used are being offered for sale to the public in contravention of the standards relating to safety, or if the trader have all the knowledge to believe that the goods are going to be unsafe for the public. Next is services which are hazardous or likely to be hazardous to the life and safety, and here also where the service provider have all the due diligence to know and that these services are injurious to life and safety. With a view to obtaining any relief provided by or under this act, a consumer can bring an action under any of the following grounds in a written form in order to obtain other relief under the Consumer Protection Act. Now, next we talk about the time frame that is there, which is given as 2 years from the cause of action has taken place. Like for example, A got his eyes operated in 1989, but again he had the hope of gaining his sight and again went for a operation 1992, but he lost his entire hope after the patient has lost his eyes, and thus filed a complaint after 1992. Here the defendant said that the time lapse it was 2 years, and there is limitation period that is operate being taken into consideration. But the court said that the cause of action arose in 1992. Hence, the period for 2 years will start from 1992 and not from 1989. Now, when we talk about appeal is filed within 30 days from the receipt of the order of the court. Wherever a person is not satisfied with the order of the court, they can make a appeal within the period of 30 days. There are various reliefs also that a complainant can take up before the court of act, like for example to remove the defects, to replace the goods with new one, to return the complainant with the price as the case may be, the charges that are paid by the complainant, to pay such amount as may be awarded, to remove the defects, to discontinue the trade fair practices, not to offer hazardous goods. So there are various relief that a complainant can ask for before the court of law. Next is there is another important aspect under this is as to who, when we talk about complainant, there is also this aspect when a complaint cannot be filed. So a complaint on behalf of the public, which consists of unidentified consumers, cannot be filed under the Consumer Protection Act. Like for example, a complaint filed on the basis of newspaper report that passenger traveling from Calcutta to Delhi were made to stay at the airport and the flight was delayed by 90 minutes, causing great inconvenience to passengers. It was held that such a general complaint cannot be taken up. Another is where an unregistered association is there, then this unregistered association also cannot file a complaint under the act. Thus, when we talk about Consumer Protection Act, it is important to understand what is the ambit within which a complaint can be filed, who can file a complaint, and on what grounds a complaint can be filed, and what are the relief that a complainant can ask for before the court of law. So this was about the basic concepts. Next class will take up rights and duties of the consumers, and we'll be taking up the different forums that are there to take up the complaint of the consumer. Thank you. Have a nice day.